Have you ever wondered what it takes to dissolve a legal guardianship? It's not as straightforward as one might think, and the process varies depending on the type of guardianship, state laws, and individual circumstances. Today, we'll explore the steps involved in terminating guardianship, delving into both temporary and permanent arrangements. Guardianship is a crucial responsibility where a guardian steps into the shoes of a parent, making all legal decisions for a child. Termination of this relationship can be a complex process, particularly when it involves permanent guardianship. In the case of temporary guardianship, this may automatically conclude after a certain period, the occurrence of a specific event, or the appointment of a permanent guardian by the court. Reasons to terminate temporary guardianship early could range from neglect or abuse by the current guardian, a change in the guardian's circumstances that affects their ability to provide care, or the parent's newfound ability to resume care. Termination can be agreed upon by all parties involved or, in the absence of unanimous agreement, petitioned through the court. The court will then assess the situation and may appoint a new temporary guardian if necessary. On the other hand, terminating permanent guardianship can be a more intricate process, often requiring court approval even if all parties are in agreement. The process for terminating permanent guardianship mirrors that of temporary guardianship, but may involve stricter criteria to prove the necessity of termination. The decision to terminate permanent guardianship is always based on the child's best interests, considering various aspects of their life, such as social interactions, education, home environment, and preferences. The courts aim to minimize disruptions in the child's life unless absolutely necessary. Now, who can request to terminate guardianship? The regulations vary by state. The guardian can voluntarily seek termination if they are unable to care for the child, while interested parties such as family members or birth parents can petition the court. However, a substantial change in circumstances must typically be demonstrated when requesting early termination, such as financial constraints or housing issues. In conclusion, terminating guardianship is a serious decision that requires adherence to legal procedures and a constant focus on the child's well-being. It's advisable to consult with an experienced lawyer to navigate the process effectively and ensure the child's stability and welfare are maintained throughout. Remember, every step taken should prioritize the child's best interests, and legal assistance can be invaluable in making this challenging transition as smooth as possible.